Police observed a vehicle weaving within its lane and then briefly hugging the fog line, and then later for a few seconds hugging the yellow solid line. Would such a driving behavior amount to reasonable suspicion that somebody's driving under the influence or violating California lane straddling traffic law to justify this stop? Well, let's find out today. And before we go on, I want to thank you for watching me here on YouTube. If you're new to the LAWSTACHE channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lawstache.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching.
Quick message from LAWSTACHE. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LAWSTACHE YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LAWSTACHE YouTube page. That's LAWSTACHE.
Today we're discussing United States versus Eric Collin, which is a Ninth Circuit case, and it deals with reasonable suspicion and a traffic stop. But first, let me give you some factual background. Around 2 a.m., an officer observed a blue Honda weaving within its own lane. Now, Mr. Collin was actually a passenger in this vehicle. Now, the driver was weaving within the own lane, and the officer made this observation from about 75 yards back. For about 10 seconds, the driver hugged the fog line, then showed the blinker and changed the lanes into the left lane. Then, for the next 10 seconds roughly, the driver hugged the solid yellow line, and then again showed the blinker and switched back to the right lane. The officer thought this was suspicious. The officer believed that the individual in the vehicle might have been driving under the influence. So he pulled over the vehicle. Both the driver and Mr. Collin appeared to be nervous. The officer observed an air freshener and a radar detector in the glove compartment. And so the officer believed that maybe these two individuals were transporting narcotics. He then asked the two individuals whether they would consent to a search of the vehicle, and they did. Now, this is a quick reminder: never consent to searches. Of course, consent is one of the exceptions to the warrant requirement under the Fourth Amendment. If the consent is given voluntarily, the officers can search the vehicle or your property in general without a warrant under the Fourth Amendment. So again, never consent to searches. Here, both the individuals consented. The officer found some narcotics in the vehicle, and Mr. Collin and the driver were charged with being in possession of methamphetamine with intent to distribute in federal court. Mr. Collin then filed a motion to suppress the evidence, the drugs that were found in the vehicle, arguing that the stop should have never occurred. He said that there was no reasonable suspicion that any crime was afoot before the sergeant pulled over the vehicle. Now, before we answer this question, let's talk about the Fourth Amendment. The Fourth Amendment protects against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before they conduct a search. Now, before they pull over the vehicle, officers need to have reasonable suspicion that criminal activity is afoot. Of course, the Fourth Amendment's prohibition against unreasonable searches and seizures applies to investigatory traffic stops. As I said earlier, to justify an investigative stop, a police officer must have reasonable suspicion that a suspect is involved in criminal activity. Reasonable suspicion is formed by specific articulable facts, which together with objective and reasonable inferences form the basis for suspecting that the particular person detained is engaged in criminal activity. An officer's inferences must be grounded in objective facts and be capable of rational explanation. Of course, we must look at the totality of circumstances to see whether the officer had a particularized and objective basis for suspecting criminal activity. Whenever we discuss traffic stops, we first must focus on reasonable suspicion and the justifications that the officers give for stopping the vehicle. Here the sergeant gave two justifications. Number one, the officer believed that the individual violated the California lane straddling traffic law. And the second justification is that the sergeant believed that the driver might have been under the influence. So first, let's focus on the California lane straddling law. California Vehicle Code 21658A, in other words, a lane straddling law, says that whenever any roadway has been divided into two or more clearly marked lanes for traffic in one direction, the following rules apply. A vehicle shall be driven as nearly as practical entirely within a single lane, and shall not be moved from the lane until such movement can be made with reasonable safety. The court then goes discussing what it means to drive as nearly as practical entirely within the lane. Does that mean the individual cannot cross the fog line or the yellow line? Or does that mean that the individual can't even touch those lines? Well, the court explains to us that the individual can in fact touch the fog and the yellow line briefly. And in this case, the court says it is reasonable for the driver to touch those lines before making a safe lane change. And how do we know it was safe? Well, the individual in this case showed the blinker and then moved over to the next lane without obstruction, without any other violations of the traffic law. So the court says it is completely reasonable for the driver to slightly weave before making a safe lane change. Because after all, the driver could be looking at the rear view mirrors before making that change. Now let's move on and talk about being under the influence. I'm not going to give you the statute because all of us know what it means to drive under the influence. Just about every state has a similar statute, and so the sergeant here believed that the individual might have been under the influence. But the court doesn't buy it. Number one, the court says that the sergeant observed the vehicle from about 75 yards out. He saw the vehicle for only 35 to 45 seconds before making a decision to pull it over. During that time, the blue Honda might have been weaving within the lane, but it was not violating any other traffic laws. It was in fact showing the indicator before changing the lanes and doing it safely. And so the court says that even though weaving might sometimes indicate that the individual might be the influence, here the court says it is substantial weaving that we're looking for. And here the driver only touched the fog and the yellow line only twice and for less than 10 seconds. The court also says that it is interesting that once the driver was pulled over, the sergeant never asked the driver whether he had anything to drink or if he was under any influence of narcotics or drugs or alcohol in general. None of those questions were presented. It is as though the sergeant right away moved into questioning about the narcotics, what later would have been found in the vehicle. The sergeant didn't even care about driving under the influence once the stop was initiated. And so for these reasons, the court says that the driver did not violate the California lane straddling law, and there was no reasonable suspicion that the driver was under the influence. Because there was no justification or reasonable suspicion to pull over this vehicle, this was in fact an illegal stop in violation of the Fourth Amendment. And what do we do if there is a violation of the Fourth Amendment? Well, the evidence that's found must be suppressed as fruits of the poisonous tree. So if you learned something today about the Fourth Amendment, reasonable suspicion, and traffic stops, give this video a thumbs up. If you're new to the LAWSTACHE channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to LAWSTACHE.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching, and I will see you next Wednesday for another deep dive on another criminal case. Thanks for watching.